Hi there once again, and welcome to Employment Hour in 30. I'm John Scholes. He is Lior Samfiru. We talk about workplace rights and that place where you spend 1,800 hours a year on average. So it's pretty important that you know your stuff, and we're here to teach you week in and week out on the show. By the way, anytime we're not doing the show and Lior can get to a phone, 1-855-821-5900 is the number to call. We'll give you that throughout the show and more contact as well. We always start off, though, my brother, with the week that was, some things that have been happening in the office as far as it's concerned in your desk, some things that would be of interest to our viewers, right? How are you?
Well, John, every single week when I'm at the office, I talk to people that have watched this show and they said, you know what, I didn't realize I have entitlements. I didn't realize there's things that actually may be owed to me. And because they saw us on the show, they call me at the office and we talk about it and we move forward to resolve their matter. And that's exactly why we're here. We're not here just because we like to be on TV. Let's face it, we kind of like being on TV. But beyond that, it's about informing people. It's about educating them about their employment rights. So if you haven't watched this show before, we talk about your job, your rights, your compensation, your severance, everything you need to know. If you're at work, you have a job, you have problems, there's solutions. We'll talk about those every single week right here. So to start off, John, a situation that came across my desk, I think there'll be a lot of people here that may be able to identify with this. I spoke with a lady. She was off on a disability leave for some time. She came back to work. She was approved to go back to work. Her doctor released her, no problem, no limitations. She was working in a plant and an assembly line. And when she came back to the plant, after a few days of working, she made a mistake, something, a bit of an accident, nothing major, but something went wrong. Well, the employer immediately jumped on it and said, well, we don't think you're ready yet to come back to work. This must be related to the medical condition you had. You have to go back off disability. Now, she tells me this had nothing to do at all with the medical condition. It was coincidence, and she'd been approved. And she told them, my doctor cleared me to return to work. She said, we don't care. We need you to be a while off, and we'll decide what to do. That's when she called me. And here's what I told her. I said, once your doctor clears you to return to work, your employer can't question that unless there's other medical evidence that they're aware of. They have to take her back to work. And if they don't, potentially that's a human rights violation. That in itself could be a termination, which means she's owed severance. So I wanted to bring this up today is that, again, as we said before, John, the doctor is the judge and jury when it comes to your ability to work. Whether you can or cannot work, the doctor has to say so. And if the doctor says so, your employer cannot question it. They cannot come up with different reasons to keep you off work. The doctor decides, and if there's any problems with that, call me.
It's an interesting and kind of unique situation, I guess, to have on this show for the first time, because usually it's the other way around.
Right.
Usually your employer is saying, you know what, I'm not letting you off work. You're not allowed to go off on disability, so stay where you are, right?
It's exactly right. And that is a very common situation where, like, no, you can't be off work, or you've been off for too long, or we don't agree. Nonsense. The employer doesn't get to make that decision. The doctor makes that decision. If you have your doctor supporting you, that's all you need. And if the employer doesn't agree, well, again, that's up to the employer to deal with. The employer also has to accommodate. Remember, John, if you have limitations, maybe you need modified duties, modified hours, because you're dealing with a medical condition, the employer has to accommodate.
EmploymentHourTV.ca is a place to go for all things about the show, and a good resource to find where we do our weekly radio show, which we've been doing, I guess we're closing in on 7 years now we've been doing that show. And during the show, of course, we take a ton of live phone calls on the air. People want to know, just like you do watching this television program. So we get the good calls. Sorry, not the good calls. We just handpick some calls. And we play them back here. Lior, I know you like to comment on whatever we air, so listen into these.
I've worked for one company for the last 8 years. I'm management. I'm going to turn 55 next month. My boss essentially has come up and said, I can't afford you, and you go on pogey. We still have to review and talk, but my question is, I'm assuming that he just wants to lay me off and, forget about any kind of notice or severance or whatever.
And first time anybody's dropped the term pogey on this show.
People still use that term. Yeah. People still use that term. So obviously for the rest of us, pogey, I guess, refers to EI, employment insurance. So this is very, very simple, John. If your employer says you're not going to be at work anymore, regardless of whether it's a legitimate reason or not, that is a termination. The fact that the company doesn't call it that doesn't change it. If I told you, John, you still work for me, you're just not going to be working for me, well, that's a termination. Right. So, of course, he's owed severance. Now, the fact that the company may be struggling financially does not change their legal obligations in terms of how much severance they pay. So, to know how much this person is owed, that's ultimately what it comes down to, how much severance he's actually owed. Well, let's use our favorite tool, severancepaycalculator.com. Let's put that information in there and see what that gives us. So he's a manager. He's been there for 8 years. You can see on the screen, 55 years old. Obviously, he wasn't given any severance because his boss wants him to just go on pogey. Well, the reality is, as the severance calculator shows, he's owed around 14 months' pay. 14 months' pay. So that's what's at stake for him. Yeah, he can also go on EI, of course, but beyond that, the company owes him 14 months' pay. And one of the reasons we wanted to talk about this particular call, or bring this call on the air, is that employers often think they can avoid paying severance. They can avoid a termination by not calling it a termination. Nonsense. It doesn't work that way. If your employer is telling you you're not working anymore, regardless of the reason, that is a termination. You're owed severance.
Again, like we always say when we show up the example with the severance pay calculator, if he had done nothing and hadn't listened to our radio show before or called in, that's 14 months of pay he might have walked away from not knowing any better.
And let me say this. Maybe it's not the nicest thing to say, but here's. If the company's struggling financially, they may not be around for a while. So he wants to get a severance now while they're still a company, because a year from now, I don't know what's going to happen. So you got to act on these things. Again,
employmenthourtv.ca is the resource, the place to go. Call number 2 coming right up.
I have somebody in work who's a boss, and he's breaking all the laws, especially smoking, wearing safety wear, and he's hard to deal with. And the more I'm dealing with it, the more he's coming down on me, an employee. So it's quite a situation, and I keep fighting it. I'm gone to the Health and Safety Act, and I just want to know if you can give me some of my legal boundaries on it.
He's dealing with the boss.
Yeah, he is. It's a tough situation. So when it comes to health and safety, there's no leeway. There's no sense of humor. Okay, these are serious situations. If you're doing work that impacts your health, you shouldn't be doing. You should stop doing that. And the law recognizes that. So the law allows you to actually refuse work that's unsafe, work that impacts your health. And even if you're not sure if it is unsafe, you may not necessarily have the expertise, you're just concerned, you can still refuse that work. The Ministry of Labor can come investigate, your employer can rectify it, but here's the key. You cannot be penalized, threatened, punished in any way for standing up for those rights, for the safety rights, even if it turns out that you were wrong. So you thought something was unsafe, the ministry came and investigated and they determined that it is safe, it's fine. You cannot be punished in any way. We call that a reprisal. So this person is allowed to stand up for his rights. He can say, no, I'm not going to do work that's unsafe. I'm going to make you deal with it, whether bring in an investigator or rectify that problem. Show me that the work is safe. And if he gets punished in any way, not only would that be a wrongful dismissal potentially, or a constructive dismissal, it could be a reprisal. So the message there for employers and employees, work safety is important. There's no leeway there. If your employee refuses unsafe work, the employer has to deal with it, investigate, and fix the problem.
Phone call, contact anytime, 1-855-821-5900 to get a hold of Lior and the member of his team when we're not doing the TV show or the radio show for that matter. We always take a topic every week, and I throw some bullet points at you, and I know you want to expand on one. A term we often use on the show, in fact, I think every show probably someone mentions it at least once, that is termination for cause. And all you need to know about that topic is what we're going to talk about.
Termination for cause is a terrible situation to be in. If your employment supposedly is terminated for cause, that means the company is saying you did something so bad, then they can let you go without severance. So that's bad enough. But how do you explain that to a prospective employer when you're looking for a job? First question they're going to ask you is, why aren't you with the previous company? Oh, they let me go for cause. Done. You'll not get a job. So we want to talk about what cause is, because in most cases, John, when people are let go for cause, there isn't cause. In fact, they've been wrongfully dismissed.
Well, that's the first question, a deeper definition. What is termination for cause?
Termination for cause happens when an employee is guilty of very significant misconduct, where that misconduct is repeated, and where the company has done everything they can to fix the problem, but they've failed. Okay, so it's reserved for the worst offenders. It's the punishment for the worst offenders. The problem is most employers jump the gun. It's not a question of whether you did something wrong. It's a question of whatever it is that you did rises all the way to the level of cause. So because of that, I wanted to understand, you may have done something wrong. It does not mean you can be terminated for cause.
Okay, rise to the level. So the next question naturally would be, how hard is it to establish termination for cause?
It is difficult because again, it's reserved for the worst offender. The company really has to build up its case. Number one, it has to prove that the employee did it. Number two, it has to prove that it was a big deal. But also number three, it has to show that there was no other possibility other than termination. So in other words, they have to show, we've warned this person before, we've warned them again, maybe we've even suspended them. What more can we do now? Nothing. So the only option is termination for cause. Most employers, in my experience, jump the queue. So they go from 0 to 100, from 0 to a termination for cause with nothing in between. That is improper, and again, that's a wrongful dismissal.
You know, we often talk about on the show that, you know, people or someone has a job and they're doing it out of malice. They're not doing it because they mean to. They just don't happen to be very good at the job. They make numerous mistakes, and eventually their employer says, that's cause. You keep messing up and I'm getting rid of you.
It is very difficult to terminate someone for cause, let's say for performance reasons. You would have to show that the employee essentially went out of their way to do a bad job. That's not true for most people. If you do your best, even if things don't work out, it does not mean you could be let go for cause.
So you have two employees. One's a 5-year guy, other's a 20-year guy or girl, and they both apparently get let go for termination for cause. Is there a difference? Does it make a difference how long you've been working for the company?
Well, the longer you work, the more difficult it is to be terminated for cause, because if you've been there for 25 years, presumably you've been there because you've been able to demonstrate you're a good employee. So to show that this good employee all of a sudden becomes so bad that they can be let go for cause, you'd have to really, really be able to show as the employer that something awful happened. So it is always difficult to terminate for cause. It's that much more difficult to terminate for cause long service employees.
The next question would be, how many, you know, so-called chances does an employee get before they can be let go for cause?
It really does depend on the offense. As a general rule, I would say 3. So you have 3 forms of discipline before you could be terminated for cause. So maybe a couple suspension or a couple warnings and a suspension, 3 warnings. Now, the more serious the misconduct, the less warnings that employer has to give you. The less serious, the more warnings. But as a general rule, if you've been let go for cause and you haven't been warned in the past, maybe 2-3 times, again, probably a wrongful dismissal.
These warnings have to be in writing, or should they be in writing?
They really should. It's very difficult to warn someone if it's not in writing. My rule, John, if it's not in writing, it doesn't exist.
Termination for cause, all you need to know. That's what we're talking about for the remainder of this segment of the show here. Do you get severance if you're fired for cause? Is there a possibility to get any severance?
Well, if you're legitimately let go for cause, then no, you won't get severance. But again, most people are not properly let go for cause. Most people, when they're let go supposedly for cause, it's really a without cause termination, which means they get full severance. So it could be the difference between getting nothing and getting as much as 2 years' pay. That's why it's so important to get some advice if you're let go anytime. But certainly if you're let go for cause.
So if we were to put on our employer hats now, how do you build a case, so to speak, to terminate someone eventually for cause? How do you do it?
You document. You document. So if the employee does something that's improper, document that, put that in writing to the employee, give them a warning, and do that every time the employee does something wrong. And at some point, you're going to look at your file and say, well, now I have the goods, I have the information that I need to let the person go for cause. You have to put in that work. If you don't, you're not going to be able to let someone go for cause.
We'll take a short break. Dependent contractor, independent contractor, are you one of those? We'll get into that a little deeper, the severance pay calculator as well, and 1-855-821-5900, anytime to reach out. Lots more. Employment Hour in 30 is on the way. Stick around.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. John Scholes, Lior Samfiru. Anytime you want to reach out, 1-855-821-5900. There's also an email address that is help@employmentlawyer.ca. But the one tool we talk about every week, and why? Because it's so important. Because over 500,000 people have used it and had their eyes open. This is what we say every week. That is the severance pay calculator at severancepaycalculator.com. Details.
You can grab your smartphone right now and go to severancepaycalculator.com. And you'll find out what you're owed if you lost your job or are concerned about losing your job. Or the worst thing, by the way, is find out what you were owed 5 years ago when you lost your job and find out, oh my God, I was owed a lot more. It's too late, though. So severancepaycalculator.com, the place you go to if you lose your job. It's easy, it's free to use, it's anonymous, there's no strings attached. It's there to help you understand what you're owed. So you walk out of the meeting with HR when they told you lost your job, you're holding those papers, they offered you 4 months pay. Is that good? Is that bad? Well, severancepaycalculator.com, you find out in seconds. And spoiler alert, it's probably not good what they've offered you, because for most people, it's not even close to being good. So once you go there, you'll answer 3 questions: your age, position, length of employment, and you are done. So check it out, even if you're just concerned, even if you're just curious, or maybe are worried about future layoffs, future terminations. Severancepaycalculator.com.
It's one thing to talk about, it's better to actually use it and give an example, right? We'll do that. 46-year-old Vivian had worked 4 years at a company when it was bought by new owners. 1 year later, she was fired without cause. Her employer said 2 weeks' pay for her 1 year of service with them. That was fair enough. That's all you're getting. Should she take it? She earned about $57,000 in a professional job.
Well, problem number one, this is very important for our viewers to understand, is that with the sale of a business, the new company, if you continue working for the new company, they inherit your service. They take it on, whether they want to or not, okay? So the problem in Vivian's situation is she worked with a previous company for 4 years, and then for 1 year with the new company, she is now a 5-year employee, not a 1-year employee. And that's going to have a huge impact on severance, okay? Now, by the way, John, even if she had only worked there for a year, she'd be owed more than 2 weeks' pay. Yeah. But let's find out how much she's owed after 5 years. So rather than me just tell you how much she's owed, let's plug that into the severancepaycalculator.com website. So she's in a professional role. She's been there for 5 years, as I just said. 46 years old, salary $57,000. She was offered 2 weeks' pay. That's so nice. Well, in fact, she's owed 8 to 9 months' pay, and that's somewhere in the $40,000 to $43,000 difference is what she's owed. $40,000. And by the way, this is a real situation. This is not something you made up. We changed the names to protect the innocent.
Yeah, right.
But this is a real situation that came across my desk very recently. So that's why the severance pay calculator works. In this case, informed the person that she's owed another $40,000. So how much are you owed? Check it out, severancepaycalculator.com.
Scary thing is she would ask her neighbor, possibly a friend, a family member, oh, you're only there a week. You're lucky you're getting 2 weeks. You were there a year.
Oh, yeah. Consider yourself lucky. It should have been 1 week when she's owed 8 months' pay. So please, get your advice from the right sources. Again, you don't like me, speak to someone else. That's fine. But severancepaycalculator.com. It's easy. You can use that anytime, any place. So check it out.
There's no charge. It's anonymous as well. EmploymentHourTV.ca. Again, the resource you want to find out where you can catch our radio show that we've been doing for years and years of much success, helping a lot of people on the show, taking a ton of phone calls on the show, and we play them back here each week, and we get your thoughts on them, Lior. We'll get to another call.
I'm currently on a disability leave, and the employer is asking for an independent medical examination. How many independent medical examinations they might be entitled to, in the case of the context of disability, of course.
The IMEs.
The IMEs. Well, this goes back to what we talked about at the beginning of the show, and that is whatever your doctor says at the end of the day trumps everything, okay? So if your doctor is clear in terms of what you need, what you don't need, your limitations, that's it. The company can say, well, we don't know, or we're not sure, or we don't like it, so we're going to have you see another doctor. No. The only time a company could legitimately ask for it if there's ambiguity, if they're not getting answers to their questions. So if the company keeps asking your doctor, tell us if he could do the job, and the doctor doesn't answer or doesn't give a good answer, well, then they say, well, we need this information, so maybe it's time to look at an IME, an independent medical exam. But if your doctor is clear, if your doctor answers the questions, yes, you can work, no, you can't, here are the limitations, here's how long it's going to be limited for, that's it. You can say no to the independent medical examination, and if your employer doesn't do what your doctor says, that could be a human rights violation, that could be a termination. It's illegal.
Being shifted from employer to contractor status, what is that all about? We're going to cover it after we take a short break. 1-855-821-5900 and help at employmentlawyer.ca as well. Employment Hour 30 rolls on. Stick around.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact: the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact: in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30. So good to have you along for the show. We are informing you about your workplace rights, the place where you spend, well, most of your life. You'd like it to be home with your friends on vacation, but no, you got to work like we all do. So we're informing you on how to conduct yourself and keeping you safe in the workplace. We do a radio show, of course. That's the Employment Hour, and you want to find out where you can find a station to catch that show online as well. EmploymentHourTV.ca is the place to go. We take calls from the show. We play them back like we did in our last segment, so we'll do another one now. And I know, Lior, you're going to comment on it.
My wife was given her termination papers last week, and she'd been working for 26 years for this very successful orthodontic practice. She's just the nicest person in the world and has no idea of how to attack this problem. So she was offered 8 weeks. That was it. She was devastated. She's broken up. The problem is she just doesn't know what to do.
You know, we love the medical community. We love doctors and, and specialists. But when it comes to employment matters,
no,
they drop the ball.
They do, and doctors are amazing in what they do. They provide such a great service. I have a lot of doctor friends, amazing people, and I have nothing but respect for doctors and the entire medical community. But when it comes to employment law, managing their employees, it's not their forte. It's not what they do, and because of that, it ends up being almost like the Wild West when it comes to workplace rights at a doctor's office, and that's extremely obvious and very prevalent when it comes to termination of employment. A doctor often doesn't know what his or her obligations are if they let someone go.
But they don't know.
Innocent. They're not trying to get away with it. Okay? But so I want you to understand, if you're working in a doctor's office, obviously the doctor is smart and educated. You can't assume, in fact, you should not assume that the doctor, they're educated, they must know how much are owed. In fact, more of a chance than ever if you're working at a doctor's office that you're not going to be offered what you're owed. So let's talk about this specific call that we got, the real call we got. We didn't plant this. So 26 years of service, obviously the person is going to be owed a lot more than 8 weeks pay. A lot more. So how can that person find out even without calling me? SeverancePayCalculator.com. So I'll just plug that in right now to the SeverancePayCalculator.com website. So in probably an administrative position, 26 years of service. I picked an age there, let's say 61. After 26 years, they're probably not 31. And they were offered 8 weeks severance. Yeah. Well, correctly, of course, the severance pay calculator says 18 to 24 months pay.
Probably closer to 24.
Probably closer to 24 months. You're absolutely right, after all these years. So that's what's at stake. The difference is 24 months to 8 weeks. It's a huge, huge difference. So that's why we wanted to bring this up here, because there's nothing unique about this question. There's nothing unique about this question that we got on air. It's a very common situation, doctor's office or otherwise. If you're let go, in most cases, you're going to be offered a fifth, a quarter, a tenth of what you're actually owed.
And you think when you really dig down into it, 2 months offered versus almost 2 years, that difference in pay, we don't know how old this person is, but if they're close to retirement age, might not be easy to get another job, first of all. Second of all, if they decide, you know what, maybe I'll ride off into the sunset, it would be nice to have that cushion to ride off into the sunset with, right?
Yeah. It's going to be more difficult for someone, let's say, that's 60 years old potentially to find a job than if you're 40 years old, okay? I mean, you know that as a 60-year-old.
What?
No, I apologize.
It's the gray beard.
That's the gray beard. No, you're not a day over 59. We know that. But it is more difficult the older you are, of course.
Yeah.
So that's why that severance is so important, John, because it's supposed to carry you until you find another position. Right. So it's important. SeverancePayCalculator.com, or call me, because you're probably owed a lot more.
Another great resource to ask your questions anytime when you don't make the phone call or watching this show, TerminationQuestions.com as well. Drop-down menu. There's a fairly good chance that your question has already been asked and answered in depth. If not, leave it there, and one of Lior's team will get to it. Example, the company has called me an independent contractor for 15 years. I'm pretty sure that I'm at least a dependent contractor. When I brought this up, they cut my commission in half. How do I respond to that?
So that's a real question that someone posted on terminationquestions.com. So let's break this down, okay? If you work somewhere for 15 years, you are not an independent contractor. You're not an independent anything if you work somewhere for 15 years. You are an employee. Let's face it, your plumber is not going to come work at your house every day for 15 years. If he did, then he's your employee. You need a new house. You need or a better plumber. But the reality is, no. If you have a regular job for 15 years, I don't care what you call yourself. I don't care what someone calls you. I don't care what you signed. I don't care how you pay your taxes. Right. I don't care if you have a business card. Okay? You are an employee of the company you work for. So what does that mean for this person? Is if they raised the issue of employment, they got their commissions cut, well, that is, of course, a constructive dismissal. Remember, your employer does not have a right to change the terms of your employment, whether it's compensation, work location, job duties.
Hours.
It's a huge one. And if they do that, if the employer still makes those changes, you have a right to treat that as a constructive dismissal, leave with your full severance. So that's what this person can do. After 15 years, they could be owed, 16, 18 months pay potentially. They could leave with that compensation. They're probably an employee. And if you're watching us right now and you believe you're an independent contractor, call me because you may well be an employee.
Again, 1-855-821-5900 is the number that Lior just mentioned to give him a call. We got time for another one of these. Terminationquestions.com, again, is the resource to ask your questions anytime. Drop them in there. Next one up says, I was just fired after 5 years of very vague performance issues, despite the fact that my team blew beyond sales expectations for the quarter. I have a feeling this is related to a discrimination issue I brought up recently involving a manager. What should I do?
Well, obviously, if you believe you're being let go because of a discriminatory reason, maybe because you feel you were harassed or because of your age, ethnicity, disability, that's a problem. Your employer cannot let you go for discriminatory reasons. The general rule, John, as you know, is you cannot be let go for any reason as long as severance is paid.
Right.
So that's the general rule. But the exception to that is you cannot be let go for discriminatory reasons. So again, I can't be let go because I have a disability or because of my age. That's illegal.
Religion, skin color, creed, doesn't matter.
You name it. It's discrimination. Or because I raised a concern about sexual harassment. Can't do that. So if the company is saying performance reasons and we don't think that's the case, there may be a different reason, and that reason could be discriminatory. So obviously we need to investigate more. With this person, I would say, well, why do you think you were let go? What happened? What gives you the reason to believe that what they're saying happened is wrong? Anytime I know a company gives a reason and I find out that reason is false, I'm starting to think, what are they hiding? And if what they're hiding is something that's discriminatory, that is a human rights violation. So of course this person is owed severance. We know that right off the bat because they lost their job. So they're owed severance. But in fact, because there's potential discrimination here, they may be owed human rights damages as well.
So it's not good enough just to say, hey, we're giving them their full 2 years severance if they owe that, regardless, because it's a human rights matter now.
Yeah. If you let go someone for discriminatory reasons, even if you pay them all their severance and more, it still doesn't change the fact that the termination itself is illegal, which means there could be human rights damages and other punishments for the employer. Your employer can never let you go for discriminatory reasons.
Slide one quickly in here. It says, my employer asked me to work overtime hours the last few weeks. She said if that extra time ends up producing results, she'll begin to pay me for it. That's nice. Does that sound right? I'm on salary.
Well, the fact that you chuckled as you were reading this tells me and tells you and our viewers everything we need to know about the fact that this is not right. If you work overtime, they have to pay for it, okay? It doesn't matter if the company is making money on it or not. If you work it, they have to pay for it. And remember, the same thing applies to salaried employees. If you're on a salary, if you work more than 44 hours a week, you still get time and a half for overtime. We simply calculate your hourly rate based on what you get in a week, and time and a half is your overtime rate, 44 hours. So even, by the way, John, even if the company doesn't approve the overtime, but you work it because you needed to work it to get the job done, they still have to pay that overtime. So beyond that, if a company wants to avoid that, could be a constructive dismissal because they're not paying you what you're owed. That could be a violation of the Employment Standards Act. It's illegal. Call me. You can also go to the Ministry of Labor if you have overtime questions, but that's illegal.
That is one of those situations where, of course, calling you first would be the proper thing to do, but you could go to the Ministry of Labor for this situation.
You cannot go to the Ministry of Labor if you lost your job. We've talked about that before on the previous shows. You absolutely can go there if there's an overtime issue, a vacation pay issue. Absolutely, yes. So this is one of those exceptions. If you have an overtime issue, they haven't paid you the overtime, they're giving you a hard time, then you can go to the Ministry of Labor for that.
Good for another week. You want to contact Lior now that we are done. It is 1-855-821-5900. help@employmentlawyer.ca. There's also employmenthourtv.ca if you want to find out where you can catch our weekly radio show. Call in and we'll play them back here on air. And as well, severancepaycalculator.com. Always go there first if you want to find out how much you're owed. That is the place to be. Till next time, Employment Hour in 30. We'll see you.
Good.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.